We find that since most of the prayers sought in the consolidated petitions have failed, coupled with the public interest nature of this matter, parties herein ought to bear their respective course. Given that the Gitobu case was resolved a decade ago, with Mr. Gitobu receiving damages of 15 million, the lapse of time justifies an upward adjustment of the award.
These are now the final orders. Arising from all that we have said, these are the orders that we make. 1, the prayer seeking to quash the resolution of the Senate to impeach His Excellency Gachagua is hereby declined. 2, a declaratory order is hereby issued that His Excellency Gachagua's fair trial rights were infringed when the Senate declined to allow an adjournment in the impeachment proceedings despite his absence. 3, a declaratory order is hereby issued affirming the constitutional necessity for Parliament to enact a dedicated statutory framework governing the impeachment of Deputy President under Article 150 of the Constitution. 4, the Court makes no findings on pension and emoluments. The first petitioner is at liberty to pursue the matter before an appropriate forum. 5, the Court awards constitutional damages of Kenya shillings 50 million to His Excellency Gachagua payable by the Senate to vindicate the Constitution, restore the dignity of the affected party, and deter future violations. 6, parties shall bear their own costs given the public nature of these proceedings. And lastly, for the avoidance of doubt, any prayer not expressly allowed herein is accordingly disallowed. Before we take leave of this matter, we wish to record our appreciation to all counsel who appeared in these proceedings and all parties for their industry, diligence, and the quality of their submissions. Your collective effort has contributed to the development of constitutional jurisprudence on this subject. We also extend our gratitude to the judiciary staff who worked tirelessly to support the bench in ensuring that this decision, the first of its kind under the Constitution 2010, was rendered in time. Thank you very much.
In this matter, the third petitioner has already filed their notice of appeal. We request that you expedite the proceedings and the judgment so that we can take it on from here. Thank you.
My Lord, my name is Diego Anjiru. I have sat here for approximately 10 hours listening to this judgment. I certainly have heard you clearly and the disposition. Equally, despite it being the judgment of the court, I do not agree with some of the issues that the court has deliberated and the conclusion the court has arrived at. And most importantly, my Lord, when we came before you, we only did not just come for judicial recommendations on legislations. We thought that, my Lord, will leave this court with a clear judgment on how a violation ought to be dealt with. When we came before you, my Lord, and we moved you, most importantly, on the issues of constitutionality of the manner in which the proceedings were conducted, we did not come here for a remedy of a legislation. It will not benefit my clients whatsoever. And for that reason, my Lord, and granted the dissatisfaction with your judgment, I have equally advised my clients for the 4th to the 49 petitioners to launch and prefer an appeal. For that reason, my Lord, would wish to be supplied with certified copies of the proceedings, the judgment, and the transcript. And for the reason, my Lord, that we need the transcript is that, my Lord, part of what was delivered by Justice Murima when he was deliberating on the issue of the plenary and the committee, I can tell you, I had never heard what he said and what he concluded. I therefore, my Lord, would wish to have the transcript provided in verbatim, so that, my Lord, we're able to deliberate and internalize them. We are otherwise not dissatisfied. We are otherwise dissatisfied, and we shall not watch when the Constitution is being buried. Thank you.
I presume we have no objection to the request for proceedings, and we have no request. We are waiting, my Lord, for the appropriate time to respond to the appeals, and so we will wait for them in the Court of Appeal. We are happy to do that. Thank you.